I have been interested in legal issues and writing on that for many years. I was also a due process hearing officer in South Carolina for 10 years and was asked by the State Department attorney or State Department of Education attorney to become a state level review officer, which is a little different to the setup you have when you do have a due process complaint under Article 7. What happens is the due process hearing is first held basically at a state level, and then if there's an appeal, that goes to a court, usually the U.S. District Court. In South Carolina, we handle it a little differently. We handle it in a way that only 7 states do. That is, when we have a due process complaint, and of course, all due process complaints start at the IEP team where there's not an agreement over some issue, and they can't agree, and so one of the options to settle disputes under the IDEA or Article 7 is to request a due process hearing. Here in Indiana, Article 7 has it at the state level. South Carolina is a little different. It's held at the local educational agency. Actually, they're often held right in the school. Where a hearing officer comes in, and you have attorneys usually representing the parents and the school district, and witnesses are brought forth and evidence is introduced. But if the losing party wants to appeal, they can appeal to the next higher level, which is the state level review officer, which I do now. And that just means I just can do the case in my house before my computer. So I just get, like the last one I did was on free appropriate public education. I got like 2 boxes of exhibits and a box of 1,000 pages of testimony, and I just read it and decide, did the due process hearing officer make the correct decision in my mind according to the law? And then if the losing party can then appeal, they appeal to usually a federal district court. So you don't have a 2-step system here in Indiana. You only have a 1-step system. In fact, all the surrounding states have this 1-step system. So I've heard a lot of cases and read a lot of cases, and I think clearly the 1 or 2 most important decisions ever in special ed have been the decision 1982 in a case called Board of Education Rowley, and another decision which was in this past year, 2017, excuse me, in a case called Andrew F. v. Douglas County School District. Now, I'm not going to talk about that a lot because we did talk about that yesterday, but what I want to do today is talk about how that decision and others really affect the issues of placing students with disabilities. And how does the law's requirement regarding least restrictive environment, how does that all fit in? So that's what we're going to be doing for the next hour or so, is talking about the Endrew decision, placement, and the least restrictive environment. Now, I do want to mention that I'm also going to be talking about official letters of policy from the U.S. Department of Education. Because the U.S. Department of Education, they're the folks that write the rules. Of course, Congress passed the idea. The federal law, special ed law, is passed by Congress and signed by the president, and that becomes law. And it's a similar system in every state. Your version of the idea, the Individuals with Disabilities Education Act, is Article 7. And Article 7 was passed by your legislator, sent to your governor, they sign it, so you have your own version of idea. Every state has their own version of the law. And so I'm going to be talking, when I talk about idea, think Article 7, because they're exactly the same thing with respect to placement decisions. But I'm also going to talk about these policy letters from the U.S. Department of Education, because what happens federally is when the law is passed, then the agency that is the agency responsible for implementing that law, in which our case is the U.S. Department of Education, they write regulations that implement the law. And so you have the idea, you have regulations implementing the idea, and in the state level you have Article 7, and you have regulations from the Department of Education, Indiana Department of Education, implementing Article 7. Although they're virtually identical. So you could say the idea is the same thing as Article 7. It is. Well, what the U.S. Department of Education ever so often does is they'll get a letter from, say, a superintendent in Fort Wayne School District, and they will ask, that person may ask them a question about implementing the idea in schools. Kind of maybe a practical question. What does placement mean in such and such area? And the Department of Education will probably answer. But when when someone writes them a letter, they don't write it back to just that person. They write what's called oftentimes a dear colleague letter. It's literally addressed to dear colleague. It means that it's an open letter, and it's the department's take on how do we implement the law. So I'm going to talk a fair amount about those too. And I want you to understand those policy letters aren't the same thing as law, but what they are is the Department of Education's interpretation of how we as special educators or administrators need to implement the law. So I just wanted to start with that beforehand. Now, let me get a little bit into the Endrew decision just in this way. Two key principles that we need to understand about Endrew before we talk about placement. And the first principle is this decision is about progress. Because what the Supreme Court did is they interpreted the law and they said what idea requires is two things. It's one thing, first it requires that we follow the procedures of law. So special ed directors are always concerned that their teachers and administrators understand the law and make sure they apply the law as is meant to be applied. For instance, procedurally, the law requires that we have so many members on the IEP team. And it identifies, both the idea in Article 7 says, these are the folks that have to be on the IEP team. That's a procedure. We have to follow that. Another procedure is we have to have parents involved at every step of the process. That's a very important procedure, and that's the first thing we have to make certain that we follow. Now, the new thing about the Endrew decision is that they also said that our IEPs that we write for youngsters with disabilities have to be reasonably calculated to allow them to make progress appropriate in light of their circumstances. So progress is the first key. Students' IEPs must be reasonably calculated to enable them to make progress in light of their circumstances. That's the new legal standard. Any case that goes to a due process hearing officer or goes to a court, even the Supreme Court, that's what they're going to ask. They're going to ask, did your IEP enable the child to make progress? Okay, that's the number one thing. Second thing, key principle, is our programs have to be specially designed to meet students' unique needs. Well, that's not a big secret. The idea begins with the word individualization. The IEP is the individualized education program, so we have to write everything for a particular student. All the decisions we make have to be individualized decisions. And this comes into play when we're talking about placement decisions. Okay, so those two key principles, very important to remember. Another principle I didn't put up, of course, is parental participation. That is a very important thing. If a court or a hearing officer would find that for some reason parents weren't involved in a meaningful way, that in itself could be a reason for a school district to lose in a court of law or a due process hearing. So that's important to understand too. Now, I talked about the U.S. Department of Education and these policy letters that they issue on a very frequent basis. They issued a letter. It wasn't actually a letter, it was a question and answer document. And what they did is they took this decision, this Endrew decision, which we talked about yesterday, and they thought, what do teachers and administrators need to know about this decision? And they boiled it down to 20 important questions. So what they did is they posed 20 questions, and then they answered them. And they're meant specifically for teachers and administrators. So this document, called the question and answer document on the U.S. Supreme Court decision in Andrew F., basically it's a FAQ. It's a frequently asked questions document, and it's really well done. I met the people who wrote it, and they had done a fabulous job. But this is what they said about placement. They said a couple of things. One of the things they said, and they emphasized, is there's no one-size-fits-all to educating children with disabilities. Rather, placement decisions, they said, must be individualized and must be made consistent with a child's IEP. That'll become a little more important later about what exactly that means. Now, they also said, and this was an answer to question 717, how does the Endrew decision affect a IEP team's placement decision? The second thing they did was to reconfirm something called the continuum of alternative placements. And I'm sure you've all heard of that. It's in IDEA, it's in Article 7. They're exactly the same thing. But what the continuum of alternative placements do is it specifies that all schools must have this entire continuum of placements, and we'll talk about that later, but includes instruction in regular classes, special schools, home instruction, placement in private schools, and instruction in hospitals and institutions. These must be available to all students in all school districts. So yesterday, for example, we had a young lady who was administrator in a very small school district. But they don't have all these different options. But what the law doesn't say they have to have them, they have to have access to them. So if in their little small school district they have a child that needs a special classroom and they don't have one, well, they've got to find one. And that's usually small districts contract with larger districts. And so that's how kids sometimes go between school districts. So, but at any rate, in this question and answer document, the Department of Education confirmed that's a really important thing, to have this continuum of placement. The other important thing to understand about this is it's not a one-size-fits-all approach. The idea is not about one thing for all students. Now, this is what the Rowley case said. This was a case in 1982. On free appropriate public education for a young girl named Amy Rowley. And one of the issues they talked about a little bit was was placement. But the decision wasn't really about that. Nonetheless, the Supreme Court addressed it. And what they said is, prior to the idea, students with disabilities were excluded entirely from public education or were deposited in regular ed classes with no assistance, left to fend for themselves in an environment inappropriate to their needs. So in a real sense, that was one of the things Congress wanted to fix back in 1975 when they passed this law, which was now is the idea, was then called the Education for All Handicapped Children Act. The name was changed in 1990. They wanted to ensure access for kids with disabilities. Because now when I went to public school quite a long time ago, I don't remember any kids with disabilities in my school, in either my elementary or my middle school, or then called junior high school. Because why? Schools could routinely exclude youngsters with disabilities. I remember vividly when I was in elementary school going to the office one day, and there was a young woman with her child there. I remember, and I think I would say now he had Down syndrome probably, and she was talking to the principal. And she was quite upset because the principal said, sorry, we don't educate youngsters with what they called mental retardation back then. That's not what we do. Well, that's exactly what happened in the idea, or the Education for All Handicapped Children Act, is Congress said, no, you can't do that. You have to, you decide to educate some segment of the student population, you've got to educate them all. That's what the Constitution says. And so that's really why the idea was first passed. Let kids into the door of public education. Prior to the idea, that didn't happen. Well, the way Congress decided to ensure that that did happen, but also that kids would get appropriate education, because remember, one of the problems is they were excluded entirely. Another problem was oftentimes they were thrown into a regular classroom. They had no assistance, no supplementary aids and services, so they just floundered in that setting. Well, Congress wanted to change that. And the way they changed that was through what was called the least restrictive environment provision of the idea. Now, of course, our focus here in this conference, our focus is on inclusion. Or there's an old term for inclusion, mainstreaming. Now, but the correct legal term that really leads to all this is least restrictive environment. Now, neither the terms inclusion nor mainstreaming are any place in the idea. They're nowhere in. If the last time I read Article 7, I didn't find either of those words in Article 7. Because really, inclusion and mainstreaming, although they sort of mean the same thing, they're not exactly. Now, the U.S. Department, they don't define mainstreaming, they don't define inclusion either. They focus in their policy letters and in the law on individualized placement determinations for every child, where you look at their particular or their unique educational needs and then make a placement decision. Now, the term least restrictive environment, that actually was coined to describe this continuum of alternative placements that I talked about. But to go back a little bit, mainstreaming is a real old term. That's the process of placing eligible children into regular ed classrooms with appropriate services that are determined by the child's IEP. And they're based on assessment. It's, provide support. Support supposedly is provided to general ed teachers. That definition came from the Council for Exceptional Children back in 1975, the same year that idea was passed. So the definition of LRE I'm going to talk about, that also comes from 1975. So that's not new stuff. There was something called the Regular Education Initiative. Way back in 1986, the head of the U.S. Department of Education's Office of Special Education Program was a person named Madeline Will. Madeline Will was the wife of George Will. They had a child with Down syndrome. And she was a very strong advocate for now what we'd call inclusion, but she called it the Regular Education Initiative. And these were some of the aspects of the Regular Education Initiative. But essentially, it was the forerunner of what we now call inclusion. But of course, you see the date was 1986. So that was also quite a while ago. Now, this is where this all comes from. This all comes from the federal law. The idea, it is also included in Article 7, and the least restrictive environment has two major principles. What those principles say is, to the maximum extent appropriate, children with disabilities are to be educated with children who are not disabled. That's the preference of the law. Kids with disabilities should be educated with children who do not have disabilities. And then second, if that is not appropriate, you can remove a child to a more restrictive setting but that may only occur when education in the regular classroom with supplementary aids and services cannot be achieved satisfactorily. So that's where everything comes from, everything about inclusion comes from that, 1975. And that was put there to make certain that kids had access. It hasn't changed since 1975. Now, the inclusion idea is same thing. Placement in the homeschool, students are based in age-appropriate regular ed classrooms, they're provided with supplementary aids and services, and it generally views special ed and FAPE, or free appropriate public education, as a service provided to students, not a particular placement. That's kind of what inclusion is. So, but if we think back to LRE, it is what lawyers would call a rebuttable presumption. And what a rebuttable presumption means is the idea in Article 7, prefer or presume that youngsters with disabilities will be educated with youngsters without disabilities. That's the presumption. It's a rebuttable presumption because it says if that is not appropriate for a child with disabilities, it could be rebutted. In other words, you could, as a team, decide that that's not appropriate given the child's individual needs. And you could move them to a more restrictive setting. That's fine under the law. So in other words, the idea prefers educating students in the mainstream, which is kind of the old term, or inclusive settings, which is the new term, but, and that's a definite preference, educating kids with disabilities and kids without disabilities. But you want to make certain that your attempts to comply with the idea do not result in something called predetermination. And I will talk about that later, but essentially what that would mean is if a school district, if your IEP team meets on a child and decides for whatever reason that we really want to educate that child in a regular classroom, but it's not appropriate for the child's needs, you could make a decision to move a child to a more restrictive setting, like a self-contained setting, for example. But if the school then said, oh no, you know, we're an inclusion school, you can't do that, they violated the law. Because that's not what the law says. The law says we do things based on the individual needs of students. No one size fits all. It'd be it'd be the same thing as if an administrator said, your son has autism, sorry, we have a special school for kids with autism. All kids with autism go to this school. Then we'll talk about a program then, but we're going to send them to that school first. That's illegal. You can't do that. It's also illegal the other way around. You can't make any one-size-fits-all decision for anyone. And here is where this question of FAPE, which Endrew decided, free appropriate public education, and LRE, or least restricted environment, sometimes conflict. Because sometimes what is appropriate for an individual child may not necessarily be the totally inclusive setting. Well, in that case, your job is clear. You have to first decide what's appropriate for the child. That's why courts time and time again have said this, just as Mary Ann Linden and Barbara Bateman said in 2012. Program appropriateness is the primary idea mandate, and LRE is the secondary mandate. So number one, what's appropriate for the child? Number two, can we educate that child appropriately in a less inclusive or a more inclusive setting? So, but that's what I mean by idea is a rebuttable presumption. Idea presumes we're going to educate all kids together, but sometimes that won't be appropriate. Then we have this other continuum. Now, this least restrictive environment principle doesn't just apply to education. court cases, there have been court cases, hearings that said it applies to non-academic settings, extracurricular activities. Students with disabilities must be afforded equal opportunity to participate in extracurricular and non-academic activities. So essentially what that means is kids have the right to be in these activities too. Now, that's been a big issue. And you know, I've seen IEPs, believe it or not, that have said little Johnny is going to be on the high school football team because that's part of his IEP. You can't do that. What you could say, little Johnny has to have the opportunity to try out for the high school football team. Disabled youngsters, you cannot say, no, you can't try out for the high school football team unless they have some sort of genetic abnormality that leads to brittle bones or something where they could injure themselves, but they have to be given an opportunity to try out. If they don't make it, well, you make football teams based on a certain set of skills, not because your IEP says it. So if they have to be given an opportunity to try out, but if they don't make it, well, a lot of kids don't make the football team. That's all right. I know we had the wonderful little film about the girl on the cheerleading team. You may have seen. That is absolutely, the law would definitely encourage that. She has the right to try out. And I've not done any cases myself, but I've seen on 504 cases in which schools said no, youngsters with disabilities cannot try out for cheerleading. Well, why not? You know, they have to be given that right to try out. The LEA must also ensure that students have these supplementary aids and services that the IEP team determines are necessary for them to participate in all these different settings. So if you decide as an IEP team, little Jimmy is going to be educated in what class, a number of classes, but that he needs a particular supplementary aid and service to be educated, you have to provide that. That's what we do in the IEP teams. Because if you think of this, the whole idea of accommodations that we make for kids to be involved in the regular classroom, it's about leveling the playing field. It's about making it so they can participate on a kind of an equivalent basis. There have been a number of cases. There was a case a number of years ago out of West Virginia where a youngster with disabilities, the parents, they determined, bless you, that the child could participate in the general ed setting, but he needed some accommodations. His name, according to the court, was John Doe because he's under 18 and his parents didn't want his name listed, so the case was called Doe v. Withers. And what happened is one of the accommodations, they were at an IEP meeting, they had a math teacher there, a science teacher, and a health teacher. And the LEA rep and the general ed teacher and, the special ed teacher, and the parents, they're all there together. And the science teacher said, well, John loves science. He is really good at it, and so he participates in class discussions, but if I have him take the tests, he's going to fail because John read at a 4th grade level. He was at the time in 9th grade, but he read at a 4th grade level. So I've said, if I give him the science tests I give everyone else, he's just going to fail. So you know what I always do? I have a peer read his test to him. And the IEP team said, that sounds great. We will put that in the IEP. John's mainstream tests have to be read to him by a peer or an aide or the teacher. And that was put in the IEP as an accommodation. And John came back after his first semester in 9th grade, and it turned out that he had a great report card, A in health, A in math, A in science, and then they went to social studies and he had an F. And the parents said, well, what's going on? John, you love social studies. You come back talking about what's going on politically all the time, and you tell us what you're studying. Why did you fail? John said, well, Mr. Withers wouldn't let anybody read the test to me. And parents were quite upset. They called the principal, and they called principals. They said, we want to talk about John's social studies grade. Mr. Withers gave him an F. And it's because he didn't read the test to him. So they had a meeting in the principal's office, and the principal said, well, you know, the IEP said everybody's supposed to read the test to John. And Mr. Withers said, well, I don't do that. He said, everybody's on a level playing field in my class. Everybody's treated the same. Not understanding the IEP is about making the playing field level. And so he didn't do it. Well, the parents wound, and you know, we live in a pretty litigious society. They sued the school, sued the school board, they sued everyone on the IEP team, but not under IDEA. They sued them under a federal law called Section 1983. And it's a law that says if you act under color of law, which means if you're working for the state, you're a policeman, you're a teacher, you're an administrator, you're a fireman, and you knowingly violate the law, you can be sued. They can come after you individually, and you could be fined for that. And what happened is they went all the way to court. The judge threw out every case except the case against John Withers, the social studies teacher, because he said, there's evidence that you violated the law because you knew that under this federal law idea, you were supposed to do this because it was in his IEP. You chose not to do it. And so went to court, went to an actual jury trial, and John Withers was found to have violated the idea because he didn't choose to honor the IEP. And he wound up being fined like $25,000 as a person. Now that's very seldom that's going to happen. But what that shows is how important these supplementary aids and services that we put in the IEP. We need to make certain that everybody is on the same page and understands what those are. Now, another important thing to understand. The regular ed setting is not the same thing as the general curriculum. You know, Article 7 and IDEA they address a number of places how we have to, our kids have to be involved in and progress in the general education curriculum. That's not the same thing as the regular ed setting. That means the curriculum has to be they have to be involved in that. And just wanted to throw that out there. Now, a couple things this means. As we've said before, everything is individualized. What you do is you make a decision on placement with respect to what the child needs. A student with disabilities should not be removed from an inclusive or general ed setting solely because of needed modifications to the general curriculum or the regular setting. So if we can make modifications that allow that level playing field, that's our job as IEP members, is to make that. Also understand, LRE generally applies to transportation unless we make other arrangements. So if the child rides a special ed bus, that's fine. But we have to make those arrangements. And again, program appropriateness is the primary IDEA mandate. Now, this is our continuum of placements. This was put in the law, actually in the regulations and in IDEA and in Article 7 way back in the 70s, 75. It says every school must have these different continuum of placement options. Well, we all have the regular classroom, clearly. We also have to have special classes. Those are generally defined by state law, and they usually involve a child being involved in a special ed classroom more than 50% of the day. If they're in a special classroom more than 50% of the day, you're moving down the continuum. If they're in a resource room, 1 hour a day, 2 hours a day, even 3 hours a day, that's considered the regular classroom. Because what are you doing? You're making, that is in essence a supplementary service to level that playing field. They need extra reading, they need extra help. So you'll never see a case in which a child is placed in a resource room for an hour a day, and a parent saying, oh no, I want the fully inclusive setting, because that is the inclusive setting. That's just that extra hour a day of additional help. So that's no more restrictive than that. We also have special schools, which are kind of going the way of the dinosaur. And that is having schools just for kids with orthopedic impairments or just kids with autism. That's kind of disappearing, or kids with emotional and behavioral disorders. You don't see a lot of those anymore. And then hospital, institution, homebound, they're considered the most restrictive of all. And the idea why Congress put this in the law is they wanted us to understand that this is where kids belong, in the regular classroom. But when we go by that one size does not fit all philosophy, sometimes we have to move to a more restrictive setting. And that's the most common restrictive setting. And why it's more restrictive is it's not a normal classroom where everybody's involved. It's somewhat different. Okay? The idea is we move them only as far down as we need to, and when their problems are ameliorated or remediated in some way, then we move them back to the regular classroom. That's what the law says we have to do. We all have to have that continuum. So literally, all schools don't need to have them, but they need to have access to all these different points if a child needs them. Now, a couple important things about the placement is deemed more restrictive the less it resembles a general education environment. And supplementary aids and services shall be used to maintain a student in the least restrictive environment of all, which is the regular classroom. And that includes a resource room, includes itinerant instruction. Those are all part of the regular classroom. Now, we live in a very litigious society. As I said, this is a map. Well, does anybody know what this is a map of? Okay, the United States. Now, look where you are here. There's Indiana right in the 7th. You're in what's called the 7th Circuit. So let's say you have an IEP meeting in the Fort Wayne Public Schools. And right way down here, oops, press the wrong button. So you have let's say it's in the Indianapolis, Fort Wayne Public Schools. Doesn't come, you don't get you can't come to a collaborative agreement with the parents. Now understand this, parents don't have a veto right over what the IEP team does. So the IEP team, say, reaches consensus that a child needs a more restrictive setting. And the parent says, no, I don't agree with that. They have the right, under this dispute resolution system of IDEA in Article 7, to file for a due process hearing. Well, let's say Fort Wayne, they have the due process hearing at the Department of Education, and the Department of Education decides in favor of the school district. Then under our system of dispute resolution, the parent has the right to go to the next higher level to appeal that hearing officer's decision. They could go, and they do this 90% of the time, to the federal courts. So they file a case in the federal court of appeals let's back up for a second. They have the right to go to the federal court. Well, you're in the Southern District of Indiana. And so each of these two districts, you can't see, but there's a little line right there. That's the Northern District of Indiana. This is Southern District of Indiana. And let's say they file an appeal with the U.S. District Court for the Southern District of Indiana. And that district decision, the district court overturns the decision of the administrative appeal or the due process hearing officer, says, no, the parents prevail. That's a real important decision, because that is law in the Southern District of Indiana. So all school districts in that district should understand what that case said, because it applies to them too. But let's say the school then decided, we're going to appeal. We don't agree with the decision. We're going to appeal to the next higher level of courts, and that's the U.S. Court of Appeals for the 7th Circuit. And that covers Wisconsin, Illinois, and Indiana. So say that case that started the IEP team, went to a due process hearing, then goes to the U.S. District Court. Now the parents appeal it to the U.S. Court of Appeals, goes before a panel of 3 judges. They don't hear the whole case again in most instances. They just listen, get the briefs from the lawyers, read the case, read the law, and decide, did the district court judge make a correct decision? Well, let's say they overturn the district court judge and decide in favor of the school district. Well, that's an even more important decision because that applies for all those states. That is now law in Indiana, Illinois, and Wisconsin. So you really need to pay attention to that because that was heard at the U.S. District Court level. And you see there are actually 13 circuit courts, one there I didn't have is the D.C. Circuit. But every circuit has a number of states that they're law in those states. And when there's a decision in the 10th Circuit, like the Endrew, that is law in all those states. There's a decision here, it's law in those states. Now, if a case gets appealed to the United States Supreme Court, like the Endrew case did, and they make a decision, that's law in the entire country. Well, how this is important in this way. There have been a number of cases, and we talked about them yesterday, and I'm not going to talk about them again today, about least restrictive environment. There was a case out of the 6th Circuit, where if you look back here, the 6th Circuit is your neighbor, Michigan, Ohio, Kentucky, and Tennessee. This decision was actually in Ohio. It was called Ronker v. Walter. And it was a very important decision. And one of the important things to understand about circuit court decisions is they have, the controlling authority is this. If it's a decision here in the 6th Circuit, it's law in all those states. But sometimes other circuits look at those decisions and say, boy, we like that, we're going to adopt that. And that's what happened in the 8th Circuit. In the case Ronker v. Walter, they adopted the 6th Circuit standard about determining LRE. Then there was a case out of the 5th Circuit called Daniel R.R. v. State of Board of Education of Texas, which covered the 2nd, the 3rd, the 5th, the 10th, and the 11th Circuit. Because what happened when we go back is, although that case was down here in Texas, it covered the 5th Circuit, Louisiana, Mississippi, it was subsequently adopted in the 3rd Circuit, the 9th Circuit, the 11th Circuit. So all those circuits followed that law. How about you guys in the 11th Circuit? You have had a very important case called Beth B. versus Van Clay, who was the superintendent of I can't remember the name of the Bluff School District, I believe, in Illinois. And that was heard by the United States Courts of Appeals for the 7th Circuit. So that is your law that you have to follow in making placement decisions with respect to the least restrictive environment. Now, so if we look at that map again, with all these different decisions, we have the Daniel R.R. decision here has been adopted here, up there, and down there, and down there. The Ronker decision was adopted there, and then we have various other decisions. We have the Rachel H., which is basically the same thing as the Daniel, and a decision called DeVries, which is basically the same thing as Ronker. And then you folks in the 7th District have the Beth B. Well, the thing about circuit courts, here's what they like to do. When they take a case, they like to give advice to due process hearing officers to lower courts to decide similar cases. So what they do is often develop tests. And that's what's happened in all of these cases. These courts have developed tests that are important from this respect for you. You have to follow these tests because if you go to a due process hearing office a decision or a court, they're going to use that test to decide if you followed the law. Well, look at this. Beth B, they didn't adopt a test. They had kind of a no test. And I'll explain why that's important for you folks in a second. But the first test, let's go back to Ronker, which is the 8th Circuit, the 6th Circuit, and for all intents and purposes, the 4th Circuit. They said a couple of things. So I'm in the 4th Circuit. If I'm an administrator of a school district and we have a placement issue with a child that may be a problem, I have to make sure, I want to make sure my IEP team or placement team is following what the circuit says. Because if it goes to a due process hearing officer, that's what he is going to rule on. He's going to use this test. And the test is this. The court is going to look at the educational services that make the segregated setting better. So in other words, they're going to do what David Bateman calls, try to determine what the special sauce is that the school district applied to make this segregated setting better. And then they're going to ask, if that does make the segregated setting better, can you move it? Can you take that special sauce and move it into the regular classroom? So that's appropriate. If you can do that, in other words, if you can make a change to a child's education that makes it appropriate for them to be educated in a segregated setting, whatever made that appropriate setting appropriate, can you move that to the general ed setting? If so, that's where you have to educate the child. That's called the portability test, because it says, in essence, whatever made that setting feasible, if that's portable to the regular ed setting, you have to do that. That's a pretty restrictive sort of test. The Daniel test is a little different. You just have to make certain as a school you're taking steps to accommodate the student in the general setting, and then you have to determine, is that appropriate for a student? If it's, academically and non-academically. And you also have to look at benefit, or what's the effect on the education of others. We had a person in our session yesterday that said, we're in a small school district, we have a wonderful little boy with autism, but he bites. He bites the teacher, he bites the aide, he bites other kids. We don't think it's safe. Well, according to the 5th Circuit, that's a legitimate consideration in making a placement decision. What's the effect on the other students? So, and if a student is placed in a more restrictive setting, is the student integrated to the maximum extent appropriate? Now, this is what, those are for the 5th, 3rd, all those other circuits. This is your test. If you have a placement controversy in your school district that winds up going to a due process hearing officer, they don't have a test to apply, because this is what happened in this case called Beth V. Van Clay. Beth B. was a 13-year-old girl with Rett syndrome, extremely, she was really very severely disabled. She was unable to speak. She was in a wheelchair. She wanted her parents, she was educated in a regular classroom. When she got to middle school, there wasn't a really good placement for her in that regular school district, but they had one, but it was a different program. It's called the ESL program. Not English as a second language. I can't remember what the acronym stood for, but it was a program for youngsters with severe disabilities. And what they wanted to do, they disagreed with that. The IEP team felt that setting was appropriate. And they said, among other things, is in this school where Beth goes, we can still mainstream her in a number of classes. They mainstreamed her in art, they mainstreamed her in social studies and health, I think. And we have reverse mainstreaming. There are certain hours of the day when the mainstream kids come to her class and work. So they had a lot of mainstreaming opportunities, but it was in essence a self-contained program, because she spent more than 50% of her school day there. Parents didn't want that. IEP team said, Beth, we believe, needs that. So they reached an impasse. the parents went to a due process hearing. The due process hearing officer decided in favor of the school district. Now, he didn't have one of those tests to go by. They then appealed to the U.S. District Court, and the U.S. District Court also held for the school district. They then appealed to the U.S. Circuit Court of Appeals for the Seventh Circuit, which also ruled in favor of the school district. So at that point, it could have gone, they could have appealed to the United States Supreme Court, but they didn't. And in fact, the Supreme Court has never heard a case on LRE. They may someday, because these circuits do kind of differ a little bit. And when circuits differ, that makes it more likely the Supreme Court will hear a case. But they haven't heard one yet. So that's as far as this case went. And here's what the Seventh Circuit Court of Appeals said. And this is kind of what is important that you understand because you're in that circuit. They said, in looking at Beth B's instance, they said, each student's educational situation is unique. We find it unnecessary at this time to adopt a formal test for district courts to apply uniformly when deciding LRE cases. The law itself provides enough of a framework for discussion. So instead we ask whether education in the conventional school was satisfactory, and if not, whether reasonable measures, accommodations, could have made it so. So in essence, they said, we're not going to use a test, but they sort of did develop a test. They said, if you can educate a child with a disability in the regular school with supplementary aids and services, that's what you need to do. You should do that. But, and here was another very interesting thing the Seventh Circuit said, the FAPE provision and LRE provision are two sides of the same coin. The first requirement, FAPE, is absolute. The second, LRE, is relative. The LRE requirement shows Congress's strong preference in favor of mainstreaming, but does not require or even suggest doing so when the regular classroom provides an unsatisfactory education. In other words, when the general ed setting isn't appropriate. And you've made those good faith efforts to educate a child, you can move a child to a more restrictive setting. Beth's parents confuse the FAPE side of the coin with the LRE side. They contend that Beth's current placement satisfies the Rowley FAPE standard because she received educational benefit at Lake Bluff Middle School. So long as the regular classroom confers some educational benefit for Beth, they argue the school district cannot remove her from the setting, but they said, no, that's not exactly the way the law works. If Beth's education at Lake Bluff Middle School was satisfactory, the school district would be in violation of the law by removing her. If not, if its recommended placement will mainstream her to the maximum extent appropriate, no violation occurs. So in other words, they said, you make those good faith efforts to educate the child in the regular classroom, in the mainstream setting. But if you can't, then you look at what's appropriate for the child and move them to that setting that is more appropriate. They said Beth was in her class about 50% of each day. Her academic progress was virtually non-existent, and her developmental progress was limited. Although the school district provided her with aids, communication devices, computerized books, and individualized curriculum, she was receiving very little benefit from her time there. And because benefit and now progress, back when this was heard, benefit was the issue. Now the issue is progress. In this case, we can say with confidence that the Lake Bluff School District's decision to remove Beth from her regular school did not violate the IDEA's mandate to mainstream disabled children to the maximum extent appropriate. Okay. Now, the LEA, why did the LEA prevail? Why did the school district win? And actually, if you look at all these LRE cases, there are certain things that are necessary for school districts to prevail in LRE cases. One, the LEA has to make good faith efforts at including all students with disabilities in the regular classroom. That's the presumption. Another thing in all these cases that were similar is that the parents were involved in the process. They didn't agree, obviously, with the school district, but they were nonetheless involved. LEA maintained excellent documentation, indicating that the student did not benefit in the general ed setting. In other words, they kept data that showed that the child was not benefiting. And finally, students were educated in integrated settings whenever appropriate. In the Daniel case, in the Beth B case, they put the child in the general ed setting whenever they could. And they made those supplementary aids and services. Yes, ma'am?
Is there any criteria for good faith attempts?
The only criteria I would say is a court or a hearing officer has to be convinced that you really tried to. So, like for instance, in Beth B's case, they gave her a communication device, and she had that with her at all times. That they considered a good faith effort. They had in the case of Daniel R.R., they had a behavioral program that all the general ed teachers were doing. That was considered, and they did it. They had evidence that the general ed teachers really did it, and they carried out those. And that's kind of an important question, though, because if they find out, like in the Withers case, that there were accommodations that weren't implemented, that's not a good faith effort. So whatever, in essence, the courts don't want to replace educators' judgments. To them, they say educators are the experts. We're not the experts. If they said we're going to really do this, or we're going to do these supplementary aids and services, is there evidence they really did it? And that would constitute, in most cases, good faith efforts. Now, if we look at why school districts lose, now they didn't lose in the Beth B case, but they lost in a couple of other cases, like the Ronker case. It was all about the LEA didn't make what the court determined to be good faith efforts to provide those accommodations that would keep Beth B or Raphael in the regular classroom. Also, the LEA failed to consider the continuum of placements. Because remember, we put up that continuum, you have to follow that. There was a case out of the Ninth Circuit called Rachel H., where the school went from the regular classroom all the way down to a special school without stopping at the special classroom. And so they said, well, you failed to consider the entire continuum. And LEAs did not document or maintain sufficient documentation. Those are other reasons that the school districts lost. Now, in terms of strategies for complying with the LRE requirement, number one, we've got to remember, that's the key term in IDEA, individualization. A student's needs and program drive the placement consideration. What I meant to say is the student's needs to successfully participate in the program drive the placement considerations. So remember, one size does not fit all. Individualization is the term. Appropriateness, FAPE comes first. So you decide first what's appropriate for the child, and then you decide where can we place the child where they receive those services. Justify, you might want to make certain that if you're moving a child to a more restrictive setting, you justify it. In fact, the idea requires, and Article 7 requires that if you place a child in a more restrictive setting, you have to explain why that's necessary. Continuum placements, don't confuse LRE with either segregation or inclusion. It's not. It's a continuum of placements. And then integration, whenever you decide a more restrictive setting is needed, you still integrate the child as much as possible. Now, I'll just go, that's just a letter from OSEP, which I talked before about Dear Colleague letters. It says, the idea requires the first consideration to be given to placement in the regular classroom with supplementary services. That's the first thing you have to consider. Can we place a child in the regular classroom. And by the way, supplementary aids and services could include behavioral supports, such as behavioral coaches, social skills, instructions, or a counselor. This is also from that letter. In general, placement teams may not place a child in a more restrictive setting solely due to a child's behavior. But it is okay to consider the safety of other students. That is a permissible area to make a decision. And also remember, you can't make placement decisions based solely on category of disability. Can't say all kids with autism go to this school for autism, or all kids with serious learning disabilities go to this school. You have to make the decision based on the child's needs, not category, disability, severity, disability, or availability of special ed and related services, or administrative sort of conveniences. You make it based on the individual needs. Now, these are just some arguments that have been used in court cases arguing against placement in regular classrooms, like the student will not receive sufficient educational benefit, it requires so much of the teacher's time and attention that a child interferes with the learning of others, child engages in significantly disruptive behavior, or requires so much modification that the child, in essence, is getting their own curriculum. Those are arguments that have been used against regular class placement. In terms of what the decisions you make, there's a few areas you really want to avoid. One of those areas is called predetermination. That's a real big no-no. That's when you decide where a child is going to go. If a court ever decides that an IEP team decided on a student's placement before the parents were involved, that's called predetermination. You would lose. That is simply something you don't want to do. Determining placement before programming. Don't do that. I've been to IEP meetings, I'm sure you have been too, where somebody says, well, the first thing we're going to talk about little Johnny's IEP team today is his placement. That's not the right way to do it. You talk about the child's needs first. Because remember, what is appropriate is the first order of the IEP team's decision-making process. Then, when you determine what's appropriate, then you discuss placement. So where must not come before what? That's a mistake. Requiring a student to fail in a regular class setting before moving him or her to a more restrictive setting. There is nothing in the law that says we've got to make certain the child fails before we move to a more restrictive setting. That's not part of the equation at all. You decide solely on basis of what's appropriate. So, just in summary on these errors, placement error, bad one. Don't predetermine a placement, either a more restrictive or a less restrictive placement, unless you first address the needs of a child. That's the definition of predetermination. Here's a couple courts that have really outlined it, I think, really well. Predetermination occurs when an educational agency has made its determination prior to the IEP meeting, including when it presents one placement option at a meeting, is unwilling to consider other options. That's predetermination. That's the kiss of death if you go to a due process hearing. So don't pre-select a placement. You come up with a placement at the meeting. And you know, the law doesn't even say the IEP team has to make the placement. They say it could be made by a separate placement team, but in all reality, it's usually made by the IEP team, which is just fine. But always consider, even if you don't agree with it, a parent's request. Always discuss whatever parents want to discuss, because that's our job, is we have to be collaborative IEP teams. Now, predetermination is not the same thing as preparation. And we don't want to mix up this. I mean, it's fine for us to have a meeting, informally or not, where we discuss before the IEP team a placement option. We just don't want to make a decision until we're at the IEP meeting with the parents. because if we make a decision, that's predetermination. If we discuss it and then make the decision later, that's just preparation, and that's fine. This is one of my favorite quotes from a case involving LRE. The judge wrote, "School officials must come to the IEP table with an open mind, but this does not mean they should come with a blank mind." So in other words, you can talk about these things. You just don't make a final decision until you're at the IEP table. We talked about this, placing a student prior to determining programming. Programming comes first. Another thing you want to avoid, there's a practice called shoehorning. Bless you, you don't want to go there. That's when you decide the placement prior to deciding the program. And what you do then is literally shoehorn a child's program into their placement. That's not an appropriate thing to do. Now, it is appropriate to write the IEP, write your special ed services, determine what's FAPE, and then say, well, these accommodations and modifications, we think these can be applied in the general ed setting. That's fine. But what you don't want to do is say, well, we're going to place the child here, and then decide the accommodation and say, well, we'll do what we can to fit them in. That would be shoehorning. So avoid that by, again, talking about what the child needs prior to deciding what the child needs. So in other words, there's a right way to do placement, and that is you do the assessment, then the programming, then you decide the placement. The wrong way to do it is you do the assessment, then the placement, then program. That's wrong. That's shoehorning. You don't want to do that. So that's kind of in summary. IEP team can, but it's not required to determine the student placement. Placement must be in accordance with that LRE principle. You got to make it at least annually. Must be based on the IEP. Must be as close to, if you decide on a more restrictive setting, must be as close as possible to the child's home school. That's a preference. The law doesn't require that, but it's a preference. And you also can give consideration to any harmful effects. So this is what that flow chart looks like. Determine FAPE, that comes first, writing the goals, services, progress monitoring, then determine the appropriate placement. Can you take that supplementary aids and services, or as David would say, the special sauce, and apply that to the general ed setting? Do it. If you can't, you move through that continuum. And always, always, always provide special ed services that are integrated to the maximum extent you can. That is, disabled youngsters, non-disabled educated together. I also put this in. This is a little more complex version of this. Placement dues. First, consider placement in the regular ed classroom. Very important with any necessary supplementary aids and services. Consider and discuss any placement requests from the parents, at least annually. And remember, LRE applies to non-academics and extracurriculars. Don't do this. Don't predetermine placement. Don't skip down the continuum. Don't make decisions based on category or severity. Make decisions based on an individual needs. And don't make placement decisions made on an administrative convenience. So, I know we don't have much time left, but if there's any questions, we have a little time, and I'm going to be around all day. So, yes?
Termination.
No, and that's a really good point. If you're in a situation where there's a discipline issue, and if it involves guns, drugs, or serious physical harm to another person, you can unilaterally, by yourself, move a child to an alternative school or a more restrictive setting. LRE doesn't even come to play then.
Now, does that have to be that process?
Mm-hmm. And those are very good ideas, but in those limited situations, child brings a gun to school or a school function like a dance, or brings drugs or solicits the sale of drugs or buys drugs or actually hurts someone, and I mean seriously hurts someone, you can unilaterally just, boom, the child's gone for 45 days. At that time, if you haven't already done it, you should have a meeting and decide what an appropriate placement is. But just for the...
That 45 days, that's not something I've heard
Okay, well, that, I'd have to look at Article 7 again. That is in the idea, and that was just added in 2004. And I think the changes of the idea are usually applied to Article 7, but I'm not sure about that. But in essence, it means you can make a unilateral change in those 3 instances, drugs, guns, or physical injury, for a child, but it can only be for 45 days, which means you've got to meet fairly quickly with that IEP team and decide what the placement needs to be. And it may be a more restrictive setting, may even be the alternative school, but that has to be made in conjunction with the parents. But for 45 days, that the parents have no say at that point in those 3 instances. Yeah, and you're absolutely right. That is it's a protection for students. Safety is always a first consideration. So, any others? Okay, well, if you email me, I'll send you a bunch of Dear Colleague letters and this question and answer on Endrew. I think you'd find that's very interesting. So just send me an email and I'll send them out today. So thanks very much for coming. Thank you.